6 months ago, the IRS told Act 22 contract holders, "We're coming to get you." So where are they? We'll talk about what is and isn't happening on this episode of Taking Shelter. I'm your host, Peter Paulson. I want to welcome back Eli Knopf, who is the head of Frost Tax Law's Controversy Group. We represent clients who either have or anticipate problems with the IRS, both criminal and civil. In the case of Puerto Rico, we talk with people who are considering a lifestyle change to evaluate the fit and talk about potential controversy issues that might come up based on their specific fact patterns. Eli, you and I recorded a video about 6 months ago when the IRS initiated a campaign that is targeted at Act 22, the individual incentives of Puerto Rican tax law. I have a video up talking about what is Act 22. I also talk about what is Act 20, the companion small business provisions, both of which have been somewhat confusingly folded into Act 60 now. Let me start with some positive energy. I think these incentives are good for the economy of Puerto Rico. I've recorded videos on how they might become more important depending on how some large corporate changes play out. And I think there's room for improvement in these provisions to further incentivize and add value to the Puerto Rican economy, particularly in the area of remote work. But the topic for today is the IRS campaign designed to review compliance with the Act 22 individual incentive provisions. So thanks for joining, Eli.
Thanks for having me.
So a lot of people know, Eli, about 15 years ago, the IRS conducted a similar exercise around the people that moved down to the United States Virgin Islands and were claiming similar incentives back then. Some of that controversy is still going on. So do you think this is kind of a quick checkup, or do you think this thing's going to play out in the long haul?
I think it's likely to play out in the long haul. Look, based on my experience with prior campaigns, I believe the IRS is going to stay on the campaign, so to speak, or on the issue, so long as they believe it'll continue to promote compliance, minimize potential revenue loss, and deter taxpayers from evading taxes or taking aggressive positions regarding residency. I mean, look, this is clearly a significant issue identified by Congress in 2019 and resulting in an enforcement announcement earlier this year. The congressional inquiry and subsequent IRS investigation resulted in findings that there are taxpayers who have stopped paying millions of dollars in taxes as a result of this election and move. And any finding like that makes it clear why the IRS took this enforcement initiative step.
And I think generally residency and bona fide residency type examinations are kind of the rage these days. I saw that New York State is issuing around 100,000 notices to people who have departed New York for, better tax treatment in some cases. And now you think about all the types of data that is available that may not have been available in 2005 with respect to cell phone data and GPS tracking information, bank reporting, and travel logs and things like that. I mean, it just seems to be, in a sense, more fertile ground now than it might have been 15 years ago.
And I agree with you on that. And historically, we've seen a lot of that data utilized at local, state level examinations for purpose of residency and domicile, whether it's locally where I am in Maryland, DC, Virginia, and they use this type of data that is now a lot more accessible to be able to challenge certain positions taxpayers are taking with respect to residency. So I think that's spot on.
So the big news, drum roll, on the campaign is that there really isn't much news. I'm not aware and have not seen any articles or any other print about any notices going out on this campaign. And after 6 months, it seems like something, in a sense, should be happening now. Are you surprised, Eli, at the timetable here?
I'm not surprised based on previous announcements for other campaigns and the time it took to take things off. And it varies from campaign to campaign. I think there's obviously a lot of factors in play. I think we can't downplay COVID's impact on the workforce with the IRS. We can't downplay, of course, the budgetary issues at play. But, look, even without all of that, it takes time to develop these types of campaigns. And what's the soft letter going to look like in drafting it and having that reviewed? Examination selections, looking at the pool of taxpayers that the IRS wants to go after and selecting which ones they're going to go after, sending that out to the field, having the field develop their plan and ultimately issue those notices. That all takes a significant amount of time. But I think a really big point to make here is just the announcement of the campaign itself, even if they're not ready to jump the next day, in and of itself has a deterrence effect, right? Hey, it got us talking about it today, right?
So the IRS in previous campaigns and kind of generally with respect to campaigns said there's a lot of communication that could come out of a campaign. To some degree, it could be just public service announcements. It could be soft letters that says we know that you're doing something, like in the case of crypto, we know that you've invested in crypto. We need some information from you. Or it could just, in a sense, jump to formal notification of examination. What do you think, if you're sitting in Puerto Rico right now, you've been there for a while, and this campaign is just kind of ready to kick off, what do you expect, or what could you expect in the way of notification?
So, I guess we can analogize it to the crypto campaign, which was, at least the most recent campaign where I saw soft letters go out. But in the crypto campaign space, there were essentially a few different types of letters that a taxpayer could have received, right? They ranged from very soft education letters to, hey, we think there might be some action that's required, or we know there's some action that may be required for you to take to come into compliance. So it's hard to say where that's going to turn out. So you can either receive potentially a soft letter, or, for those that are a little bit less fortunate, you get that, letter from the IRS saying you're being examined, and that process begins and can take a significant period of time. So yeah, I would say if you're sitting there watching this and you're somewhat concerned whether you've done things appropriately or not, I would not necessarily wait to get those soft letters or examination letters. You're in a much smaller pool of individuals that can get audited. There are only a few thousand people in general that would be subject to this campaign, whereas U.S. residents generally living in the United States, in the homeland, in the mainland, so to speak, they generally have a much lower percentage rate of audit. So I wouldn't necessarily sit back there and wait. If you're concerned, I would consult a qualified tax professional to evaluate the position you've taken.
So let's say I have waited and I get one of these soft letters. Eli, I'm an honest person. My life's an open book. I just tell my story. I send them a letter back. I say, here's, what information you're looking for. How does that play out typically?
So I always look, I've seen in many circumstances where clients come in and they have that true belief, and it's true that I'm an honest person and I didn't do anything wrong, but they're in an examination, depending on the facts and circumstances, it can go in several directions. And I think that regardless of how you personally feel about what you've done, you should consult a qualified tax professional to evaluate it and ensure you're not doing more harm by taking the approach that you're choosing to take. So from that perspective, I think it's always good to just get a gut check from someone who's been through the ringer with the IRS before and understands the process of an examination and the rights afforded to taxpayers.
Yeah, in fact, you and I had a really interesting recent case of an offshore client where the IRS did some internet work and essentially ended up alleging that this individual was leading a double life. And the alleged alter ego was not very compliant with U.S. tax requirements. And at the end of the day, it turned out to be a case of mistaken identity, but it caused some sleepless nights. And so really, you mentioned protections, rights, know your rights. I mean, what kind of rights does a taxpayer have in this case to prevent something like that from going off the rails? Well,
ultimately, the facts are going to determine the direction of the audit or the ultimate results of the audit, right? In examination settings themselves, there are rights and protections afforded to taxpayers in the exam, the audit itself. But Post-audit, there's typically appeals, administrative appeals. You've got tax court rights potentially on any deficiencies that are going to deficiency determinations that are made or any additional tax due. So I think it's really just important to consult with somebody to ensure that you understand your rights in the audit itself, and ultimately, if adjustments are going to be made, is that the final say? What other steps can be taken to try to challenge those adjustments? Because I suspect that, as with many other campaigns or topics that the IRS examines or subject matters that they examine, they typically at the agent level will not make taxpayer friendly determinations in these types of hot button or hot enforcement area topics, right? So what'll happen is they'll generally try to push this either to appeals or litigation, so that they can create, potentially if the facts are favorable to them, law that can create additional deterrent effect for them, for taxpayers considering taking these types of positions.
And we talked earlier about the digital trail of ones and zeros everybody's leaving behind with their cell phones and the GPS apps, things like that. I think that in the context of a IRS examination, there are requests for information, and in some cases you don't have to provide information, you don't have to create new information that's not already existing. Talk a little bit about that information request process.
So typically when someone gets examined, they receive an initial introductory letter introducing them to the examiner. They've selected the return for these issues that are enumerated in the initial letter. They'll then typically schedule a time to talk to the taxpayer, either via phone or in person, and issue what's called IDRs, information document requests, which are administrative requests for records. And like Peter mentioned too, generally there's no duty to prepare documents or records that don't already exist, but how you approach an examination, depending on your particular facts and circumstances, depending on how agreeable the agent can be, right? There can be certain circumstances where creating those records and cooperating can result in a more expedited completion of examination. And there are certainly circumstances where doing that may not be in the best interest of the taxpayer. So from that perspective, I think that there's a lot to consider when going into an examination, but document requests are typically how the examinations unfold, and ultimately towards the end you should receive an examination report with the initial findings that result in the ability to go to administrative appeals to challenge, and ultimately to U.S. tax court as well.
And that's the formal documentation exchange process. When I lived in Singapore, we had an IRS agent on the island, and he used to tell the story of meeting an expatriate in a bar, and the expatriate confided in him that he hadn't filed tax returns for 10 years. And then at the end, they exchanged business cards, and the agent got a big kick out of that, and we did too. It was kind of funny. But in this particular case, let's say you're in Puerto Rico, you go to a crypto event, an IRS agent happens to be there because they're real people and they invest in crypto too, and you start talking and you talk about some of your tax positions. I mean, is something like that, is it possible that could trigger an audit? Is it possible that could be used in an audit?
Well, I would probably say always get to know your fellow bar patron before talking about your personal finances and tax situation before going into that. But while I've always ever heard of something like that happening once, certainly it's possible, particularly if the position taken is one that would not pass muster and may be considered aggressive.
Well, it is a small community. Point is, it's a small community. It's a couple thousand people. There's a lot of communication. And kind of, from that standpoint, these programs in Puerto Rico have been around for around 9 years. And it's my understanding, just from the chit chat that goes around, that there have only been a handful of examinations in that process. So by staying in the background so long, has the IRS created, in a sense, a moral hazard where kind of people have been doing the best they can with the guidance they've had? And is the IRS more likely to go easy on someone who's made a good faith compliance or effort to apply what is the common understanding of the way these rules work?
Well, I think that's obviously all to be determined, and as we see how things unfold. But as with the offshore enforcement space, which we've done a lot in and continue to do a lot in, I believe that taxpayers who've acted in good faith should receive a result that reflects that behavior. With the more heavy-handed enforcement towards those taxpayers who may not have acted in good faith. Well, that being said, it remains to be seen how agents will handle these examinations and the enforcement initiative at large. I mean, early on in the offshore enforcement, we saw a bit heavier hand in the compliance procedures available to taxpayers to come into compliance and remediate their general noncompliance. But later, we saw the IRS take a more generous approach and realize that, hey, look, not everyone's a criminal, and there are other avenues we should open and other doors we should open for different types of taxpayers with different types of behaviors. So while we don't know exactly how this one will unfold and whether this will be big enough of an initiative for those types of steps to be taken, because it's only Puerto Rico specific rather than the international enforcement, which is obviously global, it'll be interesting to see how that pans out. I believe we can also glean, a softer approach for some taxpayers, similar to the crypto project or the crypto campaign, where the IRS did send soft letters, and certainly in their announcement here with the Puerto Rico initiative, the IRS did mention soft letters. So certainly, the word soft may result in some lighter touch for certain taxpayers with perhaps behaviors that aren't as aggressive. But I think what we can tell from the Congress's mandate to the IRS and the IRS looking into this and seeing millions of dollars dropping off the rolls, right, from a tax payment standpoint, I think they're likely going to focus in. It's safe to say, in my opinion, that taxpayers who are not paying significantly less moving to Puerto Rico are probably going to get some type of soft letter. But those with significant dollars in previously paid tax that are no longer paying that, I think it's safe to say that those will get a lot more scrutiny.
In the case of the 2005 USVI, the IRS kind of kicked that off. Campaigns really didn't exist back then, but they kicked that off by issuing a notice, and they said, here are a handful of things that we believe people are doing that we object to. Do you think there might be kind of a punch list that comes out here that the IRS tries to focus this program around? Or is it just going to be kind of like, let's look at all 2,000 or some amount of the returns or 8898s we have?
The IRS has limited resources, and they need to focus those resources on where it's going to make the most financial impact to the bottom line. But in addition to that, I think they're going to take the data that they receive, like they did in the offshore space, and they will work with that data to try to focus in and tailor, I think, their enforcement objectives to those specific criteria that they're identifying can result in, I guess, greater efficiency for the audit process here.
Yeah, and speaking of the audit process, so people that have moved down to Puerto Rico, say in 2020, like in the last year or so, many of them haven't filed a return, they haven't filed a Form 8898 yet, so the IRS doesn't even know they're down there. So the IRS is going to really need to lock onto an earlier year. What year of move do you think they might start with here?
That's a good question. I think that what you'll see is the general statute of limitations for audit is 3 years. So I would expect at least to begin with 2018, as that is still an open year. But it's a tricky question because if you're no longer filing tax returns in the United States, then the statute of limitations remains open because there's no 1040 filed. So technically, like we saw in the offshore space, and just in general in IRS enforcement, if there's no filed return, they can go back as far as they'd really like to with managerial approval to go back further for those years that are unfiled. So it's a statute of limitations question. Whether someone's been filing U.S. returns or not can impact ultimately how far back you go. Whether if returns were filed, was there a gross omission where a 25% or greater omission of income that can result in the IRS going back 6 years beyond the 3-year general statute? Was there fraud, which would open up a greater look back period? So I think that's a tough question to answer, but it'll be very fact specific to each taxpayer.
And if a taxpayer looks at their own facts and decides, I should have done something differently, or I made an inadvertent mistake based on kind of everybody's common understanding how these rules apply, there is a process called voluntary disclosure. The U.S. voluntary disclosure form has a box to tick in case the disclosure relates to a territory. So there's a specific contemplation of voluntary disclosure being used in the context of a territorial tax position. Talk about that voluntary disclosure process and where it might come in handy.
The voluntary disclosure practice has been around for a long time, and it was recently revised to incorporate the international elements of the closing of the offshore voluntary disclosure program a couple years back. But for purposes of our discussion today, the voluntary disclosure practice is really reserved for taxpayers with willful conduct, criminal exposure. So from that perspective, to the extent there are taxpayers who may have criminal risk, certainly a voluntary disclosure may be something worth looking into because it provides certain criminal referral protections, while it comes with some heavy-handed approach of, significant 75% fraud penalty on some of the years, some of the periods. It comes with some benefits, right? The criminal referral protection, so to speak, and the as well as a limited look-back period, whereas depending on when you moved, the look-back period may be narrowed to 6 years rather than a greater exposure if you have more years of non-compliance. But that's really for those with criminal risk. For those without criminal risk, there are other procedures to come into compliance that may mitigate some of the penalty exposure here.
And we've only talked about the U.S. side. I think I want to mention Puerto Rico has its own tax laws. They grant the incentives under a contract with the government. I heard a suggestion, Eli, that Puerto Rico might begin to ramp up its enforcement of these contractual obligations, possibly in a collaborative way with the U.S. IRS. I memean, what do you think about that?
I think it would be beneficial ultimately to have some type of procedure where because the U.S. compliance on one side impacts what needed to be done on the other side in Puerto Rico. I think it'd be nice to see some type of joint compliance initiative where you can come into compliance, either come out of compliance in Puerto Rico and do some type of remediation to remove what's been being done there, and come into compliance on the U.S. side in an efficient manner so there's no whipsaw. But at the end of the day, it would be nice to see some type of joint effort here. But like Peter said, and I think this is a really good point, Peter, and it's worth mentioning, is that these are two separate jurisdictions, right? And Puerto Rico's acknowledgement of somebody's benefits in Puerto Rico doesn't limit the IRS and what needs to happen at here in the U.S. IRS side of things, right?
Yeah, and I think that the point is you've got a contract in Puerto Rico that sets out the qualification of the incentives, but like any contract, it's going to have conditions, and the question is, are you in compliance with those conditions, substantially in compliance, or however they're going to enforce it? So Eli, in closing, let's say I moved to Puerto Rico in 2018. I have an Act 22 individual investment contract. Give me 3 bullet points that I should be focused on in advance of the action that's going to be taken under this campaign.
Right. So I guess first and foremost, don't talk to random people in bars about your personal finances. No, I'm kidding. But all jokes aside, I would say don't wait for an IRS audit. Be proactive. If you're unsure and you took these positions just kind of Googling and you didn't really hire a professional throughout this process, it's a big decision. And if there's big dollars behind it, don't wait for an audit. Reach out to a professional. Call, ask questions, and we can go through the positions that have been taken to vet risk. Secondly, I would say recognize the distinction between the U.S. and Puerto Rico tax obligations. Right, an Act 22 certificate is not going to protect you from the IRS. Right, it's just Puerto Rico specific. And finally, I would say, and like I mentioned this a little bit in the first point, is ensure you receive advice from a qualified professional, emphasis on the qualified, so that you can prepare for potential a reasonable cause standard. To the extent that you take the step and you move and it's challenged and you may lose, ultimately having that in your pocket, having that reliance on a professional can help you later on, certainly to take out any element of criminality, but certainly even from a civil penalty standpoint to help.
Very good. So one final thing, Eli, I wrote a poem about the IRS Act 22 audit. Would you like to hear it?
Sure, absolutely.
'Twas the eve of the audit, and all through the house, not a creature was stirring but my laptop mouse. The crypto investors were all snug in their beds, while visions of 100K Bitcoin danced in their heads. Then the dog started barking, a taxi horn blared. I jumped up from my desk, I became rather scared. I ran to the window and threw open the sash. The IRS was outside, They're after my cash. This has been Taking Shelter. I'm your host, Peter Paulson.